Hello, and thank you for being with us today. I'm Shauna Fine, Training Coordinator at the Minnesota Organization on Fetal Alcohol Syndrome, and we are here today for a training, Hello from the Other Side, Employment-Related Options for Young Adults, Transition Age Youth with FASD. And I will now let our presenters introduce themselves.
Hello, I'm Ann Robertson. I am a staff attorney at Minnesota Disability Law Center, where I have been for about 20 years now.
And I'm Rochelle Chen, and I am a legal advocate at the Disability Law Center. I've been there 8 years, and prior to that, I was a social worker specializing in mental health.
We're here to talk about getting kids with FASD to the other side from school to work. As a housekeeping matter, we just ask everybody to please fill out the MDLC information form and priority surveys, as this helps us know how to best focus our services. Today during the webinar, we'll learn about the Minnesota Disability Law Center and what sorts of supports are available to help individuals with fetal alcohol syndrome get the transition services that they need, especially as that relates to employment. The 4 main players in this arena are the state vocational rehabilitation services, school services, county-based services, and Social Security. And before we get started really digging into this material, we want to do a shout out to MOFAS. This project presentation was made possible by a grant from the Minnesota Organization on Fetal Alcohol Syndrome. So thank you very much. The Minnesota Disability Law Center is a part of Mid-Minnesota Legal Aid. We are Minnesota's designated protection and advocacy, or PNA, system. Our services are free for individuals with disabilities, and we get federal funds to provide these services.
Our responsibilities include monitoring of facilities, individual case advocacy, and policy advocacy. Our services are free for individuals with disabilities. We have some main topics today that we'd like to discuss. The first one is how fetal alcohol syndrome and employment, how those two things combine together, how to access services. Also, we're going to talk about vocational rehabilitation services, school-based transition age youth services, county-based services, and how SSI and SSDI, those two benefits, we're going to talk about the basics of those benefits and work incentives. Plus, if we have time permitting, we will also talk about reasonable accommodations in employment. Today, we're first going to talk about fetal alcohol syndrome characteristics that impact employment. There are common symptoms and behaviors that we want to mention. The first is kids birth to 5 years, speech and gross motor delays, extreme physical sensitivity, erratic sleeping and eating, anger, poor judgment, failure to understand consequences. At elementary age, we have blaming, volatile and impulsive, incorrect reasoning, academic failure, social problems, risk-taking, transitions that are hard and can't organize. At teenage years, we have poor social boundaries, naive and suggestible, social problems, poor judgment and memory, isolation, the person doesn't change their poor behavior, lying, and people have a tendency to be inflexible. As young adults, we see cumulative effects of problems and missed opportunities, especially for education and training. FASD can be mistaken for other disabilities such as autism, ADHD, ADD, depression, trauma, other mental health disorders, learning disabilities, and so on. There are stigmas associated with the behaviors. Now moving towards employment and support, now that we know what FASD might look like, what supports and services are available? Who might be eligible for them? How can we try to get them?
Thank you, Rochelle. It's Ann Robertson. Let's start with vocational rehabilitation services. In Minnesota, these services are provided by Vocational Rehabilitation Services and State Services for the Blind. In terms of eligibility, there are legal criteria set out. And those legal criteria are that an individual has to have a physical and or mental disability which results in a substantial impediment to employment. They must be able to benefit from VR services to achieve an employment outcome, and they have to need rehabilitation services to get ready for, find, or keep a job. SSDI and SSI disability beneficiaries are presumed eligible for VR services, and it's important to note at the outset that something called order of selection may apply. So what is VR order of selection? This is very important nowadays as it can work to delay services significantly. Order of selection, or OOS, goes into effect when the state VR agency does not have the resources to serve every eligible individual. Here in Minnesota, both VRS and SSB currently have order of selection. A way to understand order of selection is that it's the primary way under federal law that state VR agencies can manage their budgets when they don't have enough funding to serve everyone. What order selection is in terms of vocational rehabilitation services, and that's the general VR agency here in Minnesota, their first priority category serves those with 3 or more of the following functional limitations: mobility, self-direction, self-care, interpersonal skills, communication, work tolerance, and work skills. And anyone who can't show 3 or more of these serious functional limitations are placed on a waiting list. With State Services for the Blind, they have an order of selection as well, which went into effect October 1st, 2015. And State Services for the Blind currently serves those with 5 or more functional limitations. And those with fewer than those 5 are placed on a waiting list. While order of selection is in effect, it's important to understand that the VR agency must continue to serve existing consumers. Once the person with a disability has established eligibility and order of selection has been determined, vocational rehabilitation consumers work with an assigned VR counselor, one-on-one, to develop an employment plan and start services. The employment plan must identify a specific job goal, and vocational rehabilitation services can include anything that's necessary for getting and keeping a job consistent with interests and abilities. It can include things like assessment, job counseling, job placement, assisted technology rather, supported employment services, and transportation. It can also include funding for post-secondary training or schoolage, like college or community college or technical schools. It can also include the expenses of starting a small business. Again, it's very important to understand that both the VR agency and the consumer must approve the employment plan for it to go into effect. Now, here are some considerations for employment plan, or IEP, development. An employment plan is the term that Vocational Rehabilitation Services uses. IEP, or Individualized Employment Plan, is the term that State Services for the Blind uses. Some of these considerations that folks should keep in mind as the employment plan is being developed is that any assessment or evaluations must be comprehensive and individualized. The language on the plan must be concrete and clear. Predictability and repetition will go farthest to maximize success, and it's also very important at the same time to work to build flexibility into the plan as appropriate to the individual and the work situation. There should be a plan to transition to the next activity. There should be established routines, especially for this consumer population of FASD. It's important to keep things simple and specific. It should work to create and maintain structure. And above all, really, there should be a way to ensure appropriate and responsive supervision. And as consumers are going through this process and going into employment and changing employment, it is important that caregivers, parents, job coaches, etc., keep a record of what works and doesn't work. There's a new federal law called WIOA that reauthorizes the Rehabilitation Act and provides federal funding for vocational rehabilitation services. That new federal law prioritizes transition services, so that's good news for parents of kids with disabilities and FASD in particular. So these days, VRS and SSB must now dedicate 15% of the federal funding that they receive for transition services. They can provide what's called pre-employment transition services to students that aren't eligible for VR services or before VR starts. So it provides more flexibility in delivering transition services to kids with disabilities. To get the intensive one-on-one VR services that we just talked about with the employment plan, students with IEPs are presumed impaired for eligibility purposes in the VR process, but they still need to demonstrate the need for services. VR-funded transition services for eligible students may include things like work experience, vocational training, assistive technology, and supported employment services. And here we have listed some VR resources that are available online. The two VR agencies here in Minnesota, Vocational Rehabilitation Services and State Services for the Blind, the workforce centers, and an important program called Disability Benefits 101 that Rochelle will talk about a little bit later. Now let's turn to school district special education services for transition aid students. And if you have a child with FASD, you likely have some familiarity with this already. Eligibility for special ed is that a student must have a diagnosed disability. These can include things like autism, emotional behavioral disorder, developmental disorder, physical disabilities, someone who's hard of hearing or deaf, someone who's visually impaired or blind, and other things. And these are just examples of diagnosed conditions that meet eligibility criteria for special ed. In Minnesota, the student must be 14 to 21 years old for what they call transition services. And schools are required here in Minnesota to provide transition services once that child turns 14. School districts determine eligibility for services, and at the same time, parents can request that their child be evaluated and determined eligible for special education, so they can initiate that process as well. Schools must also evaluate student needs in certain areas, and these include things like work, recreation and leisure, home living, community participation, and post-secondary education or training. When developing an individualized education plan or an IEP, it is very important that the IEP include measurable transition goals as appropriate to the student's needs. And this can include things like job exploration, job skill training, visits and trial periods with employers, job support, and other skill development and accommodations. So it can really include a wide variety of things. And I have listed here some special education resources that families can turn to when they're having an issue with special ed. And first of all, of course, our school districts, special ed departments, counselors in the schools, social workers, the school principal, and various folks who do liaison work. The Minnesota Department of Education is a great resource on special ed issues. And then, of course, we have a number of advocacy groups working here in Minnesota, PACER, the ARC, NAMI, and you can access a list of disability advocacy organizations at the link that's on the slide. Now, this is a very summary information about special ed. For more information, there will be a separate MDLC webinar focusing on special ed and school-based services for kids with FASD. So please check out that webinar for training on special ed issues, and it will go into much more detail than we're able to do here. Now, a third player for funding for transition services may be county services or waiver programs, and there are 4 main ones here in Minnesota. The Community Alternatives for Disabled Individuals, CADI. The second one is Developmental Disabilities, or DD. And there are also TBI and CAC waivers. These programs have eligibility criteria of their own. They are important for individuals and families to know about since they fund one-on-one job coaching for individuals working in the community at regular jobs. So things like supported employment services are crucial to make that happen. And these programs fund a variety of services, pre-vocational services, if not funded through VR or through schools. They can also, the DD waiver program, for example, can fund things like assistive technology, employment-related day training and habilitation services, again, pre-vocational services. So lots of different services can be funded through the county. Now, to get county services, again, you have to develop a plan or an individualized services plan. This includes a person's needs and preferences for services, including employment goals, as well as long and short-term goals. It ensures health and welfare. It's supposed to be based on informed choice. It lists service types, amounts, costs, and frequency, and among other aspects includes service provider requirements and responsibilities. And it may include employment-related supports and options. Now, there are other county-based programs as well, and what we're really talking about here are federally funded health insurance programs like medical assistance. So, for example, there is medical assistance for employees with disabilities, or MAEPD. This is a very important program for folks that are working. They have to be at least age 16, a state resident, certified as disabled. They can have assets of $20,000. And they have to earn at least $65 per month and have taxes withheld. The TEFRA program is also a good program for kids who are under age 18. You have to be a state resident, again, certified as disabled, MA income eligible if the child is not in the home. And Social Security payments here are not counted. Now, some transition-related services may be covered by MA if they are medically necessary and appropriate for medical needs and support work. And this might include things like occupational therapy, physical therapy, speech therapy, social work services, psychological services, personal care assistance, assistive technology, and things of that nature. I've listed here several different links for resources to access county program funding. The county waiver programs themselves, mental health programs, MAEPD, and TEFRA. So those are all good links and resources for families struggling with county services. Now, putting it all together, we've got vocational rehabilitation, special ed, and the county. That's where things can get really complicated and challenging. The good news is that the employment plan for VR, or the IEP for special ed, and the ISP for county-funded services, these can be effective tools to help young adults move towards competitive integrated employment. And these are real jobs in the community that pay minimum wage or better. And these things can also be tools to prevent problems and give young adults support as they move towards independence. As families go through this process and kids go through this process, it's important to be aware of behaviors and misperceptions, which is a common theme with kids with FASD. When I work with kids or families, there are certain things to keep in mind when developing any of these service plans. And here are some of the questions that I ask when working with a family to get services. First thing I ask are, what are the student's goals? Second, does the family and other team members share these goals? And third, how much advocacy and self-advocacy is going to be necessary to get the services that will make these goals happen? This is where the rubber meets the road. If any of this isn't realistic, individuals need to go back to the planning process, which can be frustrating. And the takeaway of all of this is that for the best results, parents should really focus on getting the team together to wrap services around the student and work out responsibility for funding. Now, Rochelle can talk about how Social Security programs enter into all of this, and it's a whole nother level of complication and opportunity at the same time.
Thanks, Anne. If you are a parent of a child with fetal alcohol syndrome, you may or may not be familiar with some of the Social Security rules and eligibility. So we're going to talk a little bit about those programs and about work incentives that apply individually to those programs. So people with fetal alcohol syndrome can be and are eligible for Social Security benefits and work incentive programs. So we're going to talk about what is a Social Security, SSDI and SSI, who's eligible, and what are the work incentives. Let's talk a little bit first about SSI. People, I think, commonly become confused about the difference between SSI and SSDI and simply call all of those benefits Social Security. In reality, SSI is supplemental security income. It's found specifically in part of the federal law about who's eligible for SSI. People who are aged, blind, or disabled and have limited income and resources. $2,000 for an individual, and $3,000 for a couple. Some income and resources are excluded. So we like to say that SSI is a needs-based program. That means that people who are on SSI are on it both because they have limited income and because they meet this criteria of having a disability. In 2016, the federal benefit rate, or FBR, is $733 for individuals and $1,100 for a qualified couple. Let's talk about what the SSI definition is for children. To be considered for SSI, a person has to be under 18 or under 22 and attending school full-time. They have a medically determinable physical or mental impairment which results in a marked or severe functional limitations and has lasted or is expected to last for a continuous period of at least 12 months. And we have listed there a reference on the web to the Social Security guidelines. So we'll talk a little bit about SSI income and resources and wage reporting. It's very important that when people are on SSI that they make sure that they report wages and income. So they must report monthly gross wages. That is the amount before taxes or other deductions are subtracted. They must report when they start or stop working, including starting or stopping additional jobs. They must report changes of pay or income. They must report any work expenses related to their disability. Also, that includes, if you were to be blind, any work expenses. The person can report by phone, fax, mail, or in person. There is also a mobile wage reporting application that you can get through the Social Security Administration, but you have to check with them to see if you can use it. Talk a little bit about the other program, Social Security Disability Insurance. This is another program, but it's a little bit different than SSI. So typically over a lifetime when people work, they notice that on their paychecks, amounts are taken out for Social Security disability, so that later if they become disabled, those funds are used to provide them with an income. In order to be eligible for SSDI, a person has to have a work history. This person is unable to continue working at what's called substantial gainful activity, or SGA, because of a medically determinable physical or mental impairment that is expected to result in death, or has lasted, or is expected to last for a continuous period of at least 12 months. It's designed to replace earnings due to disability and insurance program. It is not income or needs-based. So this talks a little bit about the amount of work that would be needed to qualify for SSDI. So the amount of work you need depends on your age at the time your disability starts. Before age 24, you would need 1.5 years of work in a 3-year period before becoming disabled. Between ages 24 and 31, you would work during half the time between age 21 and the time the disability began. If you are age 31 or older, you work during 5 out of the 10 years before the disability began. A little bit more about SSDI and working. So when people are working, there's a thing called a trial work period. It is 9 months. It can be non-consecutive. Full benefits are paid, and it's all within 5 years. There's also an extended period of eligibility, or EPE, 36 consecutive months after the trial work period. No benefits after the first month or for next 2 months if work is at or over SGA. SSDI is terminated if your gross income earnings in 1 month are at or over SGA once you are past the extended period of eligibility. The SGA amount currently is $1,040 per month of gross, not net income. If you are blind, it is $1,640 per month of gross income. Again, it's very important that when people are working and receiving SSDI that they report their wages. So you must report when you start or stop working, when you have a change of your duties, pay, or hours, if you start paying for impairment-related work expenses. And impairment-related work expenses can be things like paying for medication, it might be paying for a van to be able to get back and forth to your job, and things like that. You can report by phone, fax, mail, or in person. You can report work efforts and any expenses incurred for work as a result of your disability. Remember to ask for and get a receipt showing your reported earnings each time. So here are some other work incentives programs. There's something called the PASS plan, the Ticket to Work, Earned Income Exclusion for SSI recipients, and Student Earned Income Exclusion for SSI recipients. So we'll talk a little bit about the PASS plan, P-A-S-S, or Plan to Achieve Self-Support. You must be eligible for SSI and SSDI to take advantage of this work incentive. You may set aside non-SSI income or resources for a specific period of time to pursue a work goal. The set-aside amount is not counted for SSI and may not be counted for other government programs. This money must be kept separate from your usual household account. You can only set money aside for expenses that will help you reduce your dependency on your government benefits. And now we'll talk about the Ticket to Work, or TTW. This is for both SSDI and SSI recipients. So the Ticket to Work increases choice. You can choose to work with an employment network, or what's called an EN, and ENs include the state's vocational rehabilitation services and private organizations that help people obtain and maintain work. SSA does not review medical condition if you make adequate progress with the use of a ticket to work. People who are ages 18 to 64 receive a ticket to work. They automatically receive that in the mail from the Social Security Administration. There's more information available at the website listed. And also to find an employment network, there's another website that's useful called chooseworkttw.net. You can click on that and find help and search for employment networks that serve people in the state of Minnesota. So there's also a work incentive that's available, but it's only for people that receive SSI benefits. It's called the Earned Income Exclusion. When calculating SSI benefits, SSA will first exclude $20 per month as a general income exclusion for any unearned income. In other words, SSDI or money from another source. In addition, SSA does not count the first $65 of the earnings you receive in a month, plus 1/2 of the remaining earnings. This means SSA counts less than 1/2 of your earnings when SSA figures your SSI payment amount. There's also something called a Student Earned Income Exclusion for SSI beneficiaries. If you are under age 22 and regularly attending school, SSA does not count up to $1,750 of earned income per month when the SSI payment is calculated. For 2016, the maximum yearly exclusion is $7,180. This is a really helpful and useful work incentive for students that are trying to go back to work, trying to try it for the first time, because it really lets you keep a lot of those earnings and set them aside without it counting against you. Some helpful resources. One of the people that folks contact is the Work Incentives Liaison at their Social Security office. These are folks that are identified in each Social Security office that know a lot about work incentives and are there to help people with going back to work issues. There's also a person known as the Work Incentives Coordinator. She is in the St. Paul office and is available to help anybody who has a work incentives issue. You can also ask for what's called a BPQI, or a benefits planning query. You can do that by going to your local office or calling the 1-800 number. There's also a booklet called the Red Book, and those are available online to order. There's also SSA wage reporting, and it talks a little bit about that website and how you can go about doing that. In conclusion, there are so many programs out there, and it can be very confusing, and we understand that, but there's help out there for you. There's a benefits planning resource. One of the things that we recommend is that people go to a website called Disability Benefits 101. This is a website where you can put in all of your benefits information, including other types of benefits, not just Social Security, but things like maybe you get a benefit through the county, maybe you're on MSIP, maybe you receive some kind of a subsidy for housing, that sort of thing. You can put all that information in and learn about available options and how to access employment. The Social Security website is socialsecurity.gov. There's the Social Security Disability Resource Center. There's also a really helpful nonprofit called the Work Incentives Connection. They are part of Goodwill Easter Seals, and they are very helpful in assisting people who are trying to understand the impact of work on benefits. And then there's our office. We are the Disability Law Center, and our website is listed, mylegalaid.org. There are also advocacy groups that are specific to disabilities, such as the MS Society.
This is Ann Robertson again, and I'm going to talk briefly about reasonable accommodations in employment. Federal Americans with Disabilities Act and the state Minnesota Human Rights Act require employers to provide reasonable accommodations to employees with disabilities. Now, discrimination laws have broader definitions about who is covered than SSDI eligibility rules, so it's important to keep that in mind. Under the ADA and MHRA, an individual has to have a record of or be regarded as having a physical or mental impairment that substantially limits one or more major life activities. Now, what are reasonable accommodations? The ADA or MHRA applies to employers with 15 or more employees. So employers that have less than that are not covered by these laws. Examples of reasonable accommodations are things like making facilities accessible, job restructuring, modified work schedules, modifying or adapting equipment or devices, providing aids, readers, or interpreters. And it is really important to understand that, especially when employers are concerned, that most reasonable accommodations are not expensive. Now, under the law, employers must do certain things to comply with the Americans with Disabilities Act and the Minnesota Human Rights Act. And those things that they must do are, number one, they have to ensure that reasonable accommodations are available. But again, the law does not require the employer to take on what they call an undue hardship. Now, factors in what an undue hardship is include the cost of the accommodation, the overall business size, the type of operation, and the workforce number or the structure of the workforce. Number two, the employer must engage in an interactive process to determine what the reasonable accommodation is, when it's going to be put into place, who's going to make sure that it happens. You know, all those things are part of a back and forth between the employer and the employee. And number three, the employer has to act in good faith at the beginning of this process and throughout. Now, what if an accommodation is refused? An employee has come forth and said that they need a reasonable accommodation for a disability. Under the law, the employer has the burden to prove it considered least restrictive or less expensive alternatives and consulted with the disabled person. A claim or a legal case can be filed, but it is very important to watch out for deadlines. An ADA claim must be filed with the federal EEOC within 300 days of the discriminatory event, and this generally comes up a lot quicker than you might expect. An MHRA claim must be filed with the Minnesota Department of Human Rights or in court within 1 year of the discriminatory event. So these deadlines are very important to keep track of, and we recommend that you consult with an attorney as you are deciding whether or not to file a claim. It's very important that you make sure that you watch and follow the deadlines, and ideally that you consult with an attorney. Now, here are some reasonable accommodation resources to access. There's the Job Accommodation Network. Minnesota Department of Human Rights has a good website. And, of course, the Federal Equal Employment Opportunities Commission. Those are all good resources to consult when in the reasonable accommodation process. Now, Rochelle is going to talk about how to access resources at the Minnesota Disability Law Center and what kind of intake process that we use.
What you can do next if you think that you need help from our office. So after listening today to all of the information we presented, you may have questions or wonder if there's something that you would be able to access services through our office. One way that you can do that, you can access our website, and there are fact sheets available. It's through the website called lawhelpmin.org. There are many available fact sheets on there, not just specific to disabilities, but ours are under the issue/disability area. We also have an intake line, and that is quite simply the best and easiest way to access our services. You can do that through two different numbers. There's 1-800-292-4150, or the local number is 612-334-5970. Those phones are answered Monday through Friday, except over the lunch hour, and we have dedicated intake staff to answer your questions and to take your intake information down. They will ask many different questions. If you're not ready to answer those questions, they may set up another time with you to do that. You can also do an intake on our website. The MDLC website is mylegalaid.org. You can just click on the area that's specific to disability, or you can look for more information there as well. The best ways to get help, doing a phone call to the client intake line or going to our website are the easiest ways to get assistance from our office. This talks a little bit again in detail about the intake process. The phone numbers are listed there, the website is listed there. You can click on Get Help, you can do an online application. If you are unsure whether you should refer someone to our office, you can also contact staff directly. We have listed our email addresses and phone numbers, but I cannot stress enough that the best way to get a hold of someone right away is by calling our intake line listed at the top. Although our individual addresses and phone numbers are listed, of course we all have several cases already that we're working on, so the best way to get a live person, immediately on the phone is to call our intake line. You can also attend an advanced training session to develop your self-advocacy skills. We will have sessions that will be scheduled. You can contact the Disability Law Center for more information and to sign up for those. For legally complex situations that meet our criteria, MDLC can provide free legal analysis and legal representation. But in order to go that route, you would need to contact our office to find out how to request this free analysis.
Thank you, Rochelle. This is Ann Robertson again. As we close this webinar, we want to thank you so much for listening today, and also many thanks to our sponsor, the Minnesota Organization for Fetal Alcohol Syndrome.